Every mile drives the economy, from the drivers who fill the shelves to the professionals, investments, and innovations that support it. Behind it all are decisions made every day, under pressure and at scale. Hosted by leaders from across the industry, this is Cents Per Mile, insights that drive better decisions, a CD Life production.
Welcome back to Cents Per Mile. I'm Karen Smirchek with Viria Trucking, and I am joined by my colleagues, Tom Albrecht of Reliance Partners and Kevin Hall of Cub Ventures and CDL Life. Before we get rolling, be sure to like, subscribe, and comment below, or head on over to centspermilepodcast.com to submit a topic for us to review on a future show. Today, we're going to be talking about trucking legal risks and having your biggest legal questions answered. Being a trucking operator, one of the things that I'm always looking at is what risks do we have in our business and how do we mitigate those risks, and really driving a safety culture to avoid the accident from happening. But we all know that accidents on the roadways with motoring public, humans, and equipment, that an accident is inevitable in every carrier's world. So I think that's kind of how Viria approaches the accident, is really just from that safety culture and investing in safety. But Tom, why don't you share some of the things that you're seeing on your end?
Well, the press reports pretty regularly on nuclear verdicts, which is commonly defined as $10 million or greater. But from the insurance perspective, and the press really hasn't picked up on this, we call a nuclear verdict anything that's 5 or 6 times greater than what a fair settlement should be. So let's say you've had an injury and the medical bills, the replacement vehicle, lost time from work, tally $300,000, just hypothetically. And then the individual is awarded $2.5 million. That's just as much of a problem as the 15 or 50 or $100 million judgment. And it's not really getting much airplay. And so whether you call that verdict creep or what, it's a big problem. And insurance companies, see, the thing is, they're built for big risk. That's why they go out and reinsure. But it's a lot of these little, not really nickel and dime, but 5 and 10x that still stay well below $10 million. That's a big frustrating point in the industry right now.
Yeah, and it's everywhere, right? It's really just not obviously you have nuclear verdict, everybody's concerned about that, but I mean, our legal risks are everywhere, from PII data. You think about even just the recruiting process and all of the data that you collect on people. And the AI now, like we mentioned several meetings back about how contracts are changing, about using people's data in learning models. It's just a vast difference. So you think about a trucking company who's doing several of those things now. Obviously, nuclear is out there, right? That's like worst case scenario, but there are so many risks throughout an organization that having sound legal guidance and having that in the top of mind obviously keeps a lot of owners up at night, for sure.
Yeah. And Tom, even with what you were saying on that verdict creep standpoint, it's the term nuclear verdict, I think, is really unknown outside of the trucking industry. And that's where I really like to use the word lawsuit abuse, because that just really shows where sometimes you're getting this request for money when there's been zero damage to the other equipment, but yet there's an injury in the vehicle. And you're kind of questioning, like, okay, how did that actually occur? So with that, I'd like to introduce our guest. Bob Plinus is a senior managing associate in Benish's litigation practice group and one of the leading law firms in this country. Bob represents a variety of commercial shippers, motor carriers, and freight brokers with regulatory compliance counseling, contract and policy drafting, and business consultation. He is also well-versed in a variety of transportation-related rules and regulations, including the federal leasing regulations, or FLRs, Federal Motor Carrier Safety Regulations, known as the FMCSRs, and the Federal Motor Vehicle Safety Standards. So with that, Bob, welcome to the show.
Thank you, everybody, and thanks for having me. Happy Monday morning. And to the topic of nuclear verdicts, I used to be a litigator a few years ago, focused solely on trucking defense and broker defense litigation, and viewed and helped clients navigate risks with nuclear verdicts and combat plaintiffs' use of reptile theory and going after trucking companies, including carriers, brokers, and sometimes even shippers.
Well, it's a never evolving landscape. So let me just kind of throw out the first question. All right. So everybody's been trying to get as many opinions as possible post the Montgomery SCOTUS case on May 14th. We know perfection's not possible, but thoroughness feels vulnerable in court, depending upon perhaps the plaintiff attorney and the circumstances. As you think about big picture wise, what areas do you believe the plaintiff industry will be assessing for vulnerabilities, particularly with freight brokers?
I think the biggest thing on my mind is having a carrier selection or carrier vetting policy, however you describe your policy, of basically selecting motor carriers. And I've seen some policies that are kind of downright unworkable or kind of impossible to comply with. And sometimes that could even be a worse fact than not having a policy at all, because then the plaintiff's attorney can point to the fact of, hey, you have a policy, but you didn't comply with it. So making sure those policies are usable, enforceable by your compliance and risk teams, and make sure the data in there is actually tied to safety data. So you can tie the requirements to, hey, this requirement is actually tied to a safety point of data where I can reduce risk in selecting a carrier.
So do you think it's possible that the industry is going to be working so hard to create a standard, but a standard that may be hard to meet because either the data can be inconsistent, like sometimes the government data comes out daily, 30 days, 90 days. For example, I think drug and alcohol is every 90 days. And then that in itself kind of creates vulnerabilities for freight brokers despite their best intentions?
I think at this point it may almost be too early to tell how it'll be used. At the end of the day, even if how a broker will be reviewed is what the broker knew at the time of hiring the carrier and whether the broker's actions were reasonable or not. So I guess if the case where the data changed after the fact, the jury should be directed to review the facts at the time the broker made the decision. But yeah, I agree. There's a number of factors that will, over time, and as courts and juries review, that will come into play more weight, more so than others, over the course of time post Montgomery.
So let me give you an example, a hypothetical, kind of a thought drill, if you will. So let's say broker A says we're only going to use motor carriers with 2 CSA scores, alerts or less. And another broker says we're not going to do that because only 35% of motor carriers have CSA scores. So we're not even going to use that. Plus, the government has also said that these are not to be used as official safety ratings. So what's the vulnerability in broker A and broker B, even though they're trying to be conscientious?
The vulnerability there would be whether or not that data can be pointed to, saying, hey, brokers using 2 of the CSA scores as opposed to all 5 is more probative of actual safety. If that data doesn't exist, then the policy doesn't make as much sense or can't be tied to an actual safety related reason.
What do you think about, Karen, when you hear that?
I think there's so many unknowns yet on how people are going to proceed coming out of it. We've seen some action, but really brokers can no longer hide behind the federal preemption to get the carrier selection lawsuits thrown out anymore. And so just seeing that happen, like I would just be curious of what either of you are thinking when it comes to a mid-size carrier. Are they going to get squeezed out, or even the smaller carriers?
Well, I think that's a big question. Where's the incubator for freight companies that are newly registered motor carriers? Freight brokers have always been that lifeline into shippers. And if just hypothetically the whole industry goes to a standard of you got to be in business at least 1 year, then the incubator program for even the best, most well-intentioned motor carriers is going to be very difficult to get established. that's almost like a separate issue aside from the law.
Bob, do you have an opinion there on how much history is enough? If I'm a brand new carrier getting started with 10 trucks, do I have the lowest paying freight because those, the higher paying freight won't select me?
So what I've seen is I've seen brokers and shippers alike really look for that 1 year in operations, or passage of the initial entry audit and then continued compliance with it. The kind of the challenge that I've and some colleagues have brought up with is confirming if you are a broker or a shipper is going to make that decision, just make sure it's based in the data that a new carrier, one that's maybe 12 months or less in operation, is actually more likely prone to cause or be involved in an accident than one that's been in service for longer. The 1 year I've seen is a pretty standard barometer. Sometimes when you get over a year, like 18 months or 2 years, then the question really becomes, hey, what would make a carrier safer? What data do you have that would make a carrier safer after 18 months as compared to 12 months or compared to 3 years?
Well, one of the big freight brokers post Montgomery went from having their standard was only have to be in business 1 day, and now it's all of 7 days. And so that's still way below what we've been talking about. But you raised some interesting points, Bob. So what reforms need to happen at the new entrance level? Because that's been pretty sloppy for a long time. What should be demonstrated maybe either right off the bat when a motor carrier's forming, or within 3 months, and then maybe a year later? There's so many holes out there, not to mention the FMCSA doesn't have the manpower. What if you were administrator for a month? How would you address this problem?
Well, I think there's a couple points. First is the registration process in itself, and that's kind of going through its own revamp with Modus, and there are plenty of considerations to talk about on that as well. It's had its hiccups, but I think the intent and the direction is right. But to make kind of an initial barrier a little bit more stringent to making sure legitimate businesses, even if they are new, but with the right mindset and right focus, are getting into the business. From there on out, having or checking to make sure policies and standards are in place that the carrier can reference in beginning operations. And that's, I think, kind of the intent of some of the new entrant audit requirements, which has gone kind of this way or that way since it's been implemented.
Trucks run on diesel, but America runs on truck drivers. Every day, they keep shelves stocked, businesses moving, and our economy alive. With nearly 60 million views and 2.9 million followers, this is where drivers live. If you are looking for drivers, they're at CDL Life.
Yeah, that's interesting, Bobby. Obviously, I'm sure Montgomery has caused your phone to ring a little bit more coming up, and a little more conversations going on. But trucking is a lot more. I hear Karen. Karen always says that they're a technology company, right? And they just happen to have trucks. I love that. There's a lot of other things, a lot of other, I'm sure, phone calls you're getting. What are some of the other hot topics that you're hearing today?
One of the big ones has been freight fraud, kind of the government's action in response to that. And we just touched on Modus, and part of the reason Modus got implemented is because of the acts that went into place to combat fraud. And then, like as we were talking about earlier, although I'm not directly involved in nuclear verdicts, combating nuclear verdict risk, what can be done at kind of the front end with policies and compliance checks that a carrier can do to kind of avoid those types of either settlements or even verdicts should there be a catastrophic accident.
Bob, can we dive into that a bit more? What is the advice you're giving to a carrier to ensure that they have the proper toolkit to avoid the nuclear verdict today?
I think that the biggest part here is during at least during the litigation strategy, to ensure folks are prepared for depositions, really, and for trial. On more of a front end, like we were talking about with Montgomery, making sure that the carrier's policies are actually defined and can be complied with by folks on the carrier team. Again, if non-compliance with a written policy can be worse than not having a policy at all. And I think that rings true for the carrier as well as the broker.
Historically, Bob, do you believe that the defense industry within trucking has argued too many technical legal points, whereas the plaintiffs have really gone to these sweeping emotional arguments? You mentioned the reptile theory earlier, but they do a lot of association. They'll put up the cost of developing a new Boeing 787 or the cost of a new iPhone, and by the time you get down to that little bitty request for 20 million, it pales in comparison to the big numbers they've been hearing. So is the industry beginning to change and battle with some of the same emotional elements, or is it still more often than not stuck in technical defense points?
From what I've seen, or at least a few years ago when I was a litigator, it was still more stuck in those kind of technical points, like your motions eliminated to exclude evidence, your attempts to redirect a jury away from a motion and back to these are the facts. This is what happened. Ultimately, though, what I've seen a lot of carriers kind of fall subject to is the traps at the trial or a deposition or another testimony where their safety folks or risks folks can't or don't answer questions correctly regarding the policies and how they were implemented. That's why I say, in the event of litigation, making sure those folks are prepared to answer, to give as kind of short and confident answers as possible is usually a big help.
So has it been a situation where maybe companies just take it for granted that the employees in those areas know the policies like the back of their hand? But like most of us, we have to check that we've read the employee handbook once a year. And some years I give it more looks than other years. But is that part of the problem sometimes? They just take it for granted. So by the time they're deposed, they're not as prepared as they should be?
I think some of the times I haven't seen that as much as what I've seen as kind of like over promising in kind of like marketing materials. Like, for example, hey, we maintain 100% compliance with all safety regulations at all times. Well, that looks great on a piece of paper, but it's just not the reality. And it could be easily turned against you in a deposition, or someone on your team who may not even know that marketing material is out there.
Yeah, and Bob, I'm sure you work in, you have colleagues in other areas. I come from the technology space, and compliance is massive, right? We have a lot of systems, a lot of controls in place to manage that because it is a risk every day. There's something new coming out every day that we have to worry about, a security vulnerability or whatever. Trucking obviously is focused a lot on nuclear verdicts, accidents, and that's obviously one of the biggest risks. But are you seeing, like, part of this problem to me seems like it's really just the systems enabling what that compliance tracking is and how advanced companies may or may not be as would relate to what those policies are, right? I mean, if you have an ISO certification or you have a insurance, Tom, I mean, look at all the compliance that you have to follow through with insurance, and you have a lot of systems in place to do that, which then expands the cost structures. It expands all of the things that a trucking company is still trying to combat regardless. How much do you think that weighs into, especially trucking? Again, it's not the most advanced industry, right? We're not talking like an insurance company or finance or healthcare or some of these others that are highly regulated as well.
I can tell you, on kind of a tangential topic, in the last couple of years, I've seen no shortage of like data processing agreements, data processing addendums be included in other like kind of service contracts. So the data and the tech piece has definitely found its way into trucking to a level that I haven't seen since I started practicing about 10 years ago. But yeah, I agree. It's a big part of the game. There are no shortage of kind of third-party vendors that carriers, brokers, shippers, everyone alike will use. One of the kind of differences that I see with some clients is making sure that there's both the kind of initial technology checks and then the ongoing monitoring. So just because, let's say, for a carrier, they're onboarded, they look great at first, but over time, if something falls off, making sure that the broker or whoever continues to confirm that carrier is compliant.
Bob, I have two questions. From the carrier side, we know that consistency beats perfection because it's not attainable. Perfection is not attainable. And we talked about the policy. So if you had to pick a number of how many pages should that safety policy be for a mid-sized carrier? I think there's carriers listening us today that have 100-page policies, 30-page policies, and no policies. So, and I heard you say no policy at all is better than the policy you don't follow. So, if somebody had to do a review of that, maybe what's the length of it and how often should they be reviewing that?
I will say I've seen policies that are between 2 and 5 pages that have been extremely effective. They check the true requirements of insurance, safety rating, and operating authority, and any other data that they can tie to that's actually probative of safety, and that policy will be very effective for carriers. I've also seen policies that are 20 plus pages that can be effective, but my kind of preference would be somewhere in that 2 to 5 pages for making sure that the standards are there and they're tied to safety data, and for the team to use that they have a usable policy that they're more likely to comply with every bullet point in, as opposed to a novel with hundreds of pages of requirements.
All right. And then on the broker side, should mid-sized brokers be looking to potentially hire a dedicated regulatory staff member now post Montgomery?
I know a good amount have, or a fair amount had them in place already. I've seen even compliance teams or risk management teams, whole teams that are responsible for vetting carriers. And just to scaling, I think it depends on the size of the number of carriers you're working with. If you're working with hundreds or even thousands of carriers, you want a larger team to ensure everyone's compliant and maintains compliance. If you're working with a lot less carriers, you may need fewer folks. But yeah, that's generally a good practice to have folks dedicated to carrier vetting, screening, and monitoring.
Do you have any thoughts on whether the cradle to grave brokerage model, which is where the individual freight broker handles getting capacity, getting the customer, servicing all along from pickup to delivery, whether that's better or more vulnerable versus the buy and sell Chicago model where you've got carrier reps, shipper reps, and they're kind of working in their own silo? Do you have any thoughts on that, especially the cradle to grave?
I haven't seen much of a different risk profile between those two. So I don't know if
So a lot of it boils down to execution again. How consistent are they? Yeah.
I think that's more the key focus really than the model is execution of how you're conducting your model, whichever you decide to use.
Got a question. The industry's talked about and implemented cameras a lot over the last 15 plus years. In the last few years, there's been some fairly large carriers go to inward looking cameras, not just outward. What are you seeing with your client base? How much adoption is there right now for the two-way camera?
I see more of it than I thought I would. There is certainly a lot of driver pushback to an inward-facing camera, which is understandable. I don't want a camera on me when I'm driving to and from work, as I expect that you guys don't either. But that said, I've seen cases where the driver-facing camera helps the carrier. It helps affirmatively disprove that the driver was distracted at the time of the accident. On the other hand, though, I've seen a case or two that, not that I've worked on directly, where the driver is clearly distracted. So it kind of functions almost like a police body camera. It can help kind of prove your innocence or lead to that indictment in some cases.
I guess the follow-up question is, are you finding that plaintiff attorneys attack motor carriers and say, well, listen, if you were comfortable with an outward looking camera, what do you have to hide by not going to an inward? I mean, how common is that attack?
I like that question, Tom. So you're saying is if you don't have, you think that the carrier has, or you're asking Bob, because the inward facing camera is so common today, are the carriers not having them adding their risk for a nuclear verdict?
Yeah. Well, Bob, what do you think? I mean,
Yeah, I mean, it is certainly something that we get brought up under reptile theory. It's, hey, you don't want to pay attention to what your drivers are doing, or you think they're doing something wrong, so you won't have a camera in there. But it's not indicative of what reasonable care is, and that's the standard here. If answered incorrectly, it certainly won't hurt certainly won't help a defense. But ultimately, the standard is reasonable care, which is judged by a number of factors by a jury, including what other carriers are doing in the industry. So I don't think it by itself would lead to a higher risk or a really lower risk of a verdict.
It would certainly be interesting to know what percent of fleets have inward facing cameras versus those that don't, because I think the outward is common even for the one truck show owner operator, right? They have that outward facing camera.
I think there's been a lot of breakdown of resistance. You know, what we saw on the insurance side was between 2019 and 2021, there were several new underwriters that came in and had a twofold requirement of requiring an outward camera and then hair follicle drug testing. And I think even though a couple of those underwriters have gone away, I think they really helped break down some of that resistance, and then other underwriters followed. So yeah, it's not what it was 7 or 8 years ago with the small motor carriers saying absolutely no way.
I think the biggest risk is having the inward facing camera and not acting on the data that you have access to. So we know that distracted driving causes accidents, and if you're not addressing the distracted driving with the inward facing camera, I think it's the same thing as the policy manual that you don't follow.
So, Bob, this whole session is really to try to give some of the folks listening out there some insights. What do you think as a motor carrier that's out there, CEO, president, their name may be on the door? What are some of the things that you think they need to be top of mind coming up in the next half? We just did a session about the halftime, right? We're halfway through the year and what to look out for the next year. What are some guidance that you can give them for the upcoming second half of the year going into 27?
We're talking about carriers, right?
Correct. Yeah.
Okay. I think kind of keeping your nose or ear to the ground on kind of some of the regulations that the government is kind of been deciding to enforce in the last couple of years, including the non-domiciled CDL rule, the English proficiency test. Those have been in place for a couple months now, or in some cases, I think more than a couple months, but still see issues pop up on those from time to time. So kind of making sure you as a carrier is abreast of what the government is doing and how it's updating these regulations or choosing to enforce them now is key to making sure your drivers maintain or stay on the road, especially with respect to the English language proficiency and the non-domiciled CDL rule.
Yeah, and yet another compliance thing to take care of, right? to make sure you have covered.
So, Bob, if you had one closing thought, and maybe this is a repeat of what you just said, what is one thing that a mid-sized carrier can do in the remaining part of 2026 to improve its litigation posture?
I think that the big thing there is making sure your policies are up to date, are enforceable, are well known by the folks on your compliance team, and are updated to reflect any changes in the law that have taken place in the last kind of 12 to 24 months, or really the last time the policy was reviewed for any updates.
Well, Bob, we definitely appreciate you joining us on our Cents Per Mile podcast. So thank you all for watching. Remember to like, subscribe, and comment, and head over to centspermilepodcast.com to tell us what you think, or if you'd like to see us cover a topic. And don't forget to watch us every Wednesday at 11:30 a.m. Eastern on FreightWaves.com or anytime at centspermilepodcast.com, YouTube, and FreightWaves.com.